So if I'm saying anything that you can't believe, trust me, you can find it in my scholarship. So, so I'm going to talk about John Dickinson, and I'm going to be talking about him in the context of the kind of the big six founders, and it really should be the big seven. So Washington, Franklin, Adams, Madison, Hamilton, Jefferson, and Dickinson. Dickinson, many of you probably either haven't heard of him or haven't heard very much about him or only negative things, probably because he did not sign the Declaration of Independence, but he was America's first celebrity. And without him, the revolution would not have been a success. That is the conclusion that I've come to after looking at him for 25 years. And what is so interesting about Dickinson for our purposes is that of the big seven, he was the one who was most overtly religious and motivated by, I guess, what we would call a more sort of traditional religion. And I mean, traditional doesn't really work in this context, but hopefully as I go along, you'll see what I mean. So Dickinson was raised in a Quaker family. He worked and lived in the Quaker environment of Pennsylvania, and he married into the leading Quaker family in the colony, and his wife was a Quaker, and they raised their daughters as Quakers. And this is their formal name is the Religious Society of Friends. And you might know them. They're not Amish, they're not Mormons. They still exist today, and they're probably best known for being pacifists. Now, although Dickinson was raised in this environment and worked in this environment, and the older he got, the more Quakerly he became, he never actually joined the meeting. And that's a critical thing to remember. And the reason he never became a Quaker is because he said he believed in the lawfulness of defensive war. In other words, if a nation is attacked, they have the right to defend themselves. That was a God-given right. So that was the main reason he didn't want to become a Quaker. So just keep that in mind because it's important. But in every other way, especially as he got older, even his close friends and enemies didn't know he wasn't a Quaker. So Quakers dressed plainly. They spoke plainly using the plain speech, thee and thou instead of you and your. And they sort of other things, they took up causes such as abolitionism and education, and they were very sort of active in those sorts of social justice movements. So Dickinson showed early on in his career that religion was very important to him. In his letters home when he was in London for legal training at the Middle Temple, he wrote about the political corruption in England, and he was appalled by it. And even at that young age, he was maybe 21, 22, he said that he thought there really needed to be a reformation of manners, a reformation in morals, in other words, and that people were sort of led astray when they rejected religion. So he thought religion was important for the morality of a people, and this included the English. When he went back to Pennsylvania and began to practice law in 1757, he very much cared about Quaker causes. And one place we see this most clearly is in what was called the Campaign for Royal Government, where Benjamin Franklin and Joseph Galloway in the Pennsylvania Assembly tried to abolish the 1701 Charter of Privileges, which was the Pennsylvania Constitution, and place Pennsylvania under a royal government. And Dickinson said that would be a crazy idea because the Pennsylvania Constitution was the only major constitution that actually provided religious liberty of conscience for the people of Pennsylvania. And if they got rid of that, there was no guarantee that the Quakers would retain their unique religious liberty. And just sort of following what Michael was saying, Quakers were persecuted at least as badly as the Catholics, and in fact worse in some ways, because they sought it out to become martyrs, and they would intentionally break laws and challenge the authorities, and so they were persecuted by really brutality, beatings, whippings, branding, tongues being bored through with hot irons, imprisonment, which was kind of worse than death, and so they endured this in England and in the colonies, especially in Massachusetts. But they owned Pennsylvania, they controlled Pennsylvania, and they also controlled New Jersey and Rhode Island to a large extent, and they were a political presence in every colony. So Dickinson was very concerned about preserving the religious liberty in Pennsylvania. and he said at this time, religion and government are certainly very different things, instituted for different ends, the design of one being to promote our temporal happiness, the design of the other to procure the favor of God and thereby the salvation of our souls. And he said, improperly mixing these two things deluged the world in blood. So this was his attitude as of 1764. Now, going forward, as we enter sort of the era of the American Revolution, Dickinson brought Quaker practices to the American people. He actually he sort of orchestrated the resistance to Britain. He gave ordinary Americans a plan to follow to resist Britain that they adopted, and he advocated the Quaker theory and practice of civil disobedience. This was what Quakers invented in England in the 1660s to agitate for their religious liberty. So he suggested the same practices to the American people to resist the British, and they adopted those and used them for a time until they became impatient, and sort of sentiment sort of started to shift towards towards actually revolution and independence. So one of the biggest myths of the American founding, or the American Revolution in particular, is that it was Whigs against Tories, sort of, the revolutionary Whigs against the Tories who supported the crown. That's not actually what happened. Yes, there were Tories, there were people who were loyalists, absolutely, but they were not especially organized and not really didn't have a lot of popular support behind them, so really it was actually the Whigs against the Quakers. And what I mean by that is that the Quakers controlled Pennsylvania, which was the most central, one of the largest colonies, controlled the biggest port. It was the cultural and geographical center of the colonies, and they did not want independence. And Dickinson was their leader at this point, and so if the Quakers in Pennsylvania did not want independence, it wasn't going to happen. So Dickinson had to agree, basically, to allow independence to go forward and write instructions to the Pennsylvania delegates so that they would agree to vote at least not against independence. And so it's a complicated story of the Quakers versus the Whigs during this period. Now, critically, in June 1776, a mere days before the Declaration of Independence was voted on, and Dickinson knew it was going to happen. He did not want independence. He did not think America was ready. And so one of the things that he did to prepare America for independence was he wrote the first draft of America's first Constitution, the Articles of Confederation. And in that draft, there is one of the most significant documents of the era. It's a little scrap of paper. It's just a paragraph long. Usually I have it up on the screen. Sorry about that. And it's a religious liberty clause for America's first Constitution. And in that, he basically provides that the colonies, as they became states, would basically, all of the religious rights would be sort of frozen where they were, so that nobody could lose religious rights going forward in the Revolution. And what he was worried about specifically was that the Quakers would be persecuted for the obstruction that they had made, and they had enemies in Pennsylvania from way back, the Scotch-Irish Presbyterians, and if they got control of the Pennsylvania government, the Quakers would be persecuted. So Dickinson wrote this clause, and not only did he write religious liberty and protection for religious rights into this clause, he also changed the language as he was writing it from saying, his or her religious liberty, his or their religious liberty. He changed it to his or her religious liberty, thus giving women protection for their religious rights. And also he included the word practice, the practice of their religion. And what that meant is that Quaker women were the only women in early America who were allowed to be ministers. So writing this clause, he provided protection for women's religious liberty and their freedom of public speech. So that is, I believe, the most revolutionary move of the Revolution. But it was outright rejected, just rejected out of hand. It was excised and never made another appearance in the Articles of Confederation, along with a number of other provisions that he wrote. And then, of course, immediately the Quakers were targeted, and they were rounded up, denied habeas corpus, held without charge, and exiled to Virginia for 9 months, the leading Quakers in Philadelphia. So Dickinson predicted that. So going forward after the Revolution, and I have to kind of rush through this, Dickinson, he had been known as sort of a political figure, but after he went into the 1790s and he retired from office, he started to be known as a theologian, and he was writing and thinking a lot about theology and about religion, and he said at this point, there is a relation between the principles of religion and the principles of civil society, and he said the Bible is the most Republican book that was ever written. And he really believed that people ought to be free to find their religion, and that ought to shape their behavior in a moral sense. And we've wondered a long time, well, what did Thomas Jefferson mean by pursuit of happiness? We don't have to wonder what Dickinson meant. He said this. He said, "We never consult our own happiness more effectually than when we most endeavor to correspond with the divine designs by communicating happiness as much as we can to our fellow creatures." Being happy was following God's law to bring happiness to other people. So that's really quite significant. What he worried about was religious zealots who might try to impose their religion on other people. Quakers believed that everybody was equal under God, and that they had to find God for themselves. And he was very concerned about those who, in their overweening zeal for religion, would direct the governor of the universe, that is God, and suppose a possibility of advancing it by injuring the cause of liberty. I lament their error. So Dickinson was a pillar for religious liberty throughout his career and the intersection of religious morality and public life. So thank you.
This would allow the chaplain to reflect the religious faith of the people in that unit, though he writes in this general order, I have 14 chaplains for 28 regiments. So increasingly, chaplains have to serve above the regimental level. Chaplains, and the Revolutionary Army is raised by states. The two exceptions would be the artillery and the Canadian regiment. And that is something I literally never encountered the Canadian regiment quite recently. We did try to unsuccessfully invade Canada. There's a sort of interesting pattern here, both with the Revolution, the War of 1812, and others, wanting to acquire Canada. It has not worked that well. But one of the legacies is we do get some Canadian refugees. The Congress actually forms its own regiment, the Canadian regiment, and remarkably appoint a Roman Catholic priest as chaplain to this regiment. One of the reasons I've been intrigued about looking at the Revolution is Fred Anderson wrote a really fascinating study of why Massachusetts provincials fought for the imperial cause in the 7 Years' War, and it's a remarkable account on the importance of religiosity in the daily life of soldiers and what motivates them to fight. And he really sees two things. One, he sees anti-Catholic sentiment as really crucial, and that chaplains are really important, along with individual leadership of commanders. You want commanders leading at the front. And in accounts of the coming of the revolution, the Quebec Act is a real concern, granting Catholic rights in Canada, and is not going to be precedent in an era when many colonies have clauses that disenfranchise Roman Catholics. And during the Revolutionary era, there exists a remarkable embrace of religious pluralism and a dropping of anti-Catholic sentiment. For example, George Washington, when he instructs Benedict Arnold in how he should conduct himself in the invasion of Canada, he says, he orders to avoid all disrespect or contempt of the religion of the country and its ceremonies. Prudence, policy, and true Christian spirit will lead us to look with compassion upon their errors without insulting them. While we are contending for our own liberty, we should be very cautious about violating the rights of conscience in others, even ever considering that God alone is the judge of men, and to him only is this case, are they answerable? The other question I think to look at why religion? Why have chaplains? Why promote religion in the military, especially given the shortages of funds? Why spend money on the chaplains? And I think there are sort of two I think important reasons strikingly in both the Revolution and World War II. For example, we find in World War II, the Roosevelt administration and faith-based organizations formed the USO, basically to keep GIs out of gin joints, brothels, and gambling dens. I mean, they're really worried about the corruption of American GIs, and this is echoed in the Revolutionary era. John Adams, when writing to Nathaniel Greene, they're writing about appointment of a chaplain, particular chaplain. Adams declares to Greene, he thinks like the problem of recruiting in May of 1777 is not simply because the American army hasn't done well of late, but he says, the prevalence of dissipation, debauchery, gaming, profaneness, and blasphemy terrorizes the best people of the continent from trusting their sons and other relations among so many dangerous snares and temptations. Multitudes of people who would with cheerful resignation submit their families to the dangers of the sword shudder at the thought of exposing them to what appears to them the more destructive effects of vice and impiety. And Greene agreed with this. Greene thinks that chaplaincy is very important in part for moral suasion. But the question always to me is, how effective is moral suasion? For example, Washington, in both establishing the chaplaincy in the Continental Army, or affirming that when he becomes commander-in-chief, chaplains had been present when he arrived, but he really sort of solidifies that. I mean, he is, observers, and he himself says, the camp is bad. My ears are filled with the most shocking oaths and slanders. The tremendous name of God is taken in vain in the most trifling circumstances. One surgeon writes in spring of 1777, in observing the men in his unit, death is not a subject not to be attended to by the soldier. Hell and damnation is at almost everyone's mouth from the time they awake to the time they fall asleep. He notes that despite official orders that mandate the attendance at divine services, both Washington and subordinate commanders would mandate attendance at divine services. Officers looked for excuse not to attend, as did enlisted personnel. And he also noticed at one point that the regimental chaplain was absent, and he reflects in his diary. Our chaplain does not yet return. The regiment is extremely happy in his absence, as they cannot bear to hear Edwardianism preaching with the same degree of pleasure as a living animal can bear hot burning coals. So Edwardian President Jonathan Edwards, this minister was clearly from the Jonathan Edwards tradition, toward Calvinism. This did not play well with the troops. Now, of course, there are soldiers that remain devout. I mean, one problem we have in terms of the average soldier is we just don't have many of their writings. Or the writings we have, I looked at some of the pension records, no real mention of chaplains. Jeremy Greenman leaves us one of the few wonderful diaries of a common soldier. And he does attend divine service. He does religious work, but it's a frustrating work. He is not like a Puritan wrestling with the state of his soul. You would love to have more of these accounts. In both the Revolution and World War II, and I think in other wars, it is not simply moral suasion, but the chaplaincy from the perspective of commanders is to encourage people to fight. They are in many ways the political commissars, to use a term from the Soviet army. They are explaining why soldiers fight, and in surviving sermons, this really comes through. And of course, for texts in the Revolution, you often rely on the Hebrew Bible with lots of stories of combat and war. Often the comparison is, America is the new Israel. Compared to World War II, the chaplain's role in the Revolutionary War is much narrower. There's a real class, I think, chasm between the average soldier and the chaplain. I think there's less fraternization. There's less emphasis on pastoral work, pastoral care with the centerpiece of later-day chaplains, except for hospital chaplains. I read one diary of this one chaplain, and I was shocked at how much time he had to read and work on his sermons. This just didn't happen in the World War II chaplaincy. The chaplaincy was a very liminal position in really up until the 20th century. In the Revolutionary Army, they didn't wear uniforms. They were not given military rank. And while they were subject to military discipline, Washington at one point complains they're leaving the encampment without permission. A significant case of pastoral counseling takes place under sort of the worst circumstances. Chaplains would attend to those to be executed, to be hanged. And one gets a sense of why you have established religion in the military. And this is sort of, I think, very tragic for this individual. This account is given of an execution at Valley Forge in January of 1777. This day there was a man hung here for deserting and carrying 2 criminals away with him. He was a Roman Catholic and a very ignorant fellow to look at, if to judge from appearance. He was allowed the privilege of a chaplain, but there was none of his persuasion. They could not think it very essential, and at the time he was swung off. So in other words, this Catholic was denied the sacraments. He was denied absolution. This was a major concern, for example, of the Catholic hierarchy in World War II, that Catholics have access to the sacraments, particularly when they are going to be in harm's way. So finally, I want to say, what is the religious life of the revolutionary officer and the soldier? And I was frustrated in World War II because I knew a lot about the inner life of chaplains, and it was harder to get at average soldiers. They're not like Puritans. They're not even like a lot of Civil War soldiers. I remember reading this one diary of a Roman Catholic who's very good about going to Mass, but he writes more about the movies he saw than he sees than about his religiosity. We know Washington remains an Anglican Episcopalian throughout his career. We know that religion, he will make a lot of statements in support of religion. Again, it's frustrating. We don't have an inner life of him on religion. The thing of Green is fascinating because here's a case where religious values are not that important. Green will, in fact, disavow the Quaker value of combat, of not participating in war. He will be read out. He will be essentially excommunicated from his Quaker meeting. At the end of the war, a Quaker writes to him, sort of saying, given your past, basically your background, will you give up abandon slavery? And of course, he does not. He accepts the gift of a plantation and becomes a slaveholder. One thing that I find that at one point when you look at the revolution in religion, it really does change. I mean, it's interesting on the national level. There is a disestablishment of religion. We don't create a national church, and I've often actually wondered if New England had only succeeded, would the national church have been congregational, or if only the British had been successfully able to loop off the southern states, would the national religion of the South have been Anglican? You know, the fact there is such religious pluralism within the Continental Army and within the nation is one of the reasons I think it's very clear why you don't have a national religion. I would also add that I'm always surprised by historians of civil religion, and even how often no one really looks, in a lot of ways, at the military, because in an era where there is disestablishment in a number of states on the part of the national government, there is an establishment of religion within the Continental Army. Ministers are paid. There's official orders that mandate attendance at religious services. While the Jeffersonian Republicans would be skeptical of the chaplaincy, and the chaplaincy would almost completely extinguish in the armed forces, it has been one of the most consistent things in the last 250 years of establishing a religion within the military. Now, I would also add, it's very problematic, and even though I'm supportive of it, you know, you have all kinds of issues when the government establishes religion. I mean, the two most things that jumped out at me in World War II was the Army mandating that a Protestant minister would provide services to all Protestants. So you have Protestant services led by a member of the Church of Latter-day Saints, all the way to a high church Episcopalian. And then the appointment of chaplains. The Navy refused it, only appointed one Christian Scientist because they didn't have an ordained clergy, despite the fact there were women ministers. The chief of chaplains, particularly the Army, was determined we are not going to have women ministers. He didn't even want women as chaplains assistants. There is a real tension when you do establish a religion, because the state does intrude to the free exercise of religion. But thanks for this. I really appreciated this opportunity extended to me to really dig into the revolution.
Very much, Mike, for that kind introduction, and to Ryan and Leela and the whole team for their kind invitation and hospitality. It's wonderful to be back on FSU's campus and at a peak season of the year, I must say. So I'm very grateful for this warm welcome and this opportunity to speak about religion and the founders. Now, when most Americans think of the religious influences on the founding, if they think of this at all, they usually focus on major figures like Jefferson, Madison, Franklin, and then conclude from the lives of those particular figures that religion's influence on the founding must have been very minimal and was more concerned with guarding against religion than promoting it or protecting it. This false impressionistic thinking may reflect more on current religiosity or lack thereof in contemporary society than on any serious historical investigation. In fact, in times of greater religiosity in the United States, say in the 19th century, Americans tended to focus on unapologetically religious figures at the founding and then conclude from that there must have been a great emphasis on religion at the founding. Now, in our decidedly more secular age, there seems to be less influence on the founding because we are making history in our own image, depending on the century in which we are situated. So if we want to avoid that history is in our own image, we need to look at the historical sources anew and ensure that we are attentive to the complexity and nuance of our past. Now, that sort of sensitivity is very hard to model in 15 minutes, so let me focus on one small segment of this vast topic. If we want a complete picture of religion and the founders, the topic of our panel, we need to look at more than just the big founders who get HBO series named after them. We also need to avoid the triumphalism on either side of the religious and secular coin. Now, at the risk of biting my own critique, I do want to focus on the religious aspect, because of course that is my charge this morning. But I do want to avoid at least the big founders and look at a few Catholic founders, very much footnotes to the founding. Now, at first glance, it might seem surprising that there were Catholics at the American founding at all, let alone those who had some influence. After all, anti-Catholicism in early America was extremely prevalent, very deep in the colonial American experience. But I want to argue that there were Catholics who did influence, directly and indirectly, some of the key texts of the American founding. And to make this point in these brief remarks, I want to focus on two relevant parts vis-a-vis religion and the founding in the U.S. Constitution: the No Religious Test Clause, Article 6 of the Constitution, and of course, the First Amendment to the Constitution. So let's first turn to Article 6 of the Constitution, the prohibition on religious tests for public office. Now, the most direct cause of Article 6 was constitutional framer Charles Pinckney, who was not Catholic, and as far as I know, was not influenced by Catholic thought or the Catholic Church or Catholics in general at all. So Pinckney is our most proximate direct influence of Article 6. So I think we have to keep that in mind as I explain some of the Catholic context to this. But when we search for causes in historical inquiry, we're not just interested in the most proximate cause, what philosophers call like the efficient cause, the thing that does the most direct kind of work. We also want to know what we might call contributing factors or final reasons or underlying circumstances, right? Foundational kind of work as well. Now, there were Catholics who directly supported a no religious test for public office. For example, the first Catholic bishop in the United States, John Carroll, published an argument against religious tests for public office in a Philadelphia newspaper during the Constitutional Convention at the same city in which Pinckney had addressed the very issue. Carroll then published another article against religious tests for public office right before North Carolina had its second ratifying convention. So Bishop Carroll here is clearly trying to influence the debate such as he can. He writes anonymously, but he's trying to influence. But we might even call this more of a confluence, right, rather than a direct influence here, because the river toward religious prohibition of religious tests for public office is going to flow whether Bishop Carroll writes his article or not, right? So it's more like a tributary to a river than the river itself. But nonetheless, at least a context worth considering of a priest intervening in public debates, right, on this question. So to understand Catholics influencing Article 6, we need to understand the general context to religious tests in the kind of Anglo-American legal sphere. Religious tests in Britain and most of the American colonies were often directed at Catholics specifically. With a few exceptions, most notably in Maryland, the default was to prohibit Catholics from public office, and indeed much of Maryland colonial history even prohibited them from public office as well. So why did the constitutional framers accept a clause without much debate that went against this long-standing prohibition? That seems to be the question that we need to ask if we're going to ask about causal influences. And what's more extraordinary about this article is that it's not just silent on the question of religious tests for public office. It explicitly prohibits them. We could have just put this in a kind of suspended limbo, right? If we don't want to talk about religious tests, and we'll sort of let the states figure it out, or we'll make it ambiguous. But it's an explicit prohibition. So to answer the question about influence and religion, we need a much more nuanced way of understanding causal influence, not just the proximate cause like Pinckney. So consider the cause of removing something, right? What's the cause of a door slamming, for instance? Someone could push it closed, a wind could blow it shut, or someone could remove the door stopper, and then the door closes. It's the latter that I sort of want to emphasize now, right? This removal of something that is a cause of something happening. So in our case, American Catholics had removed what was thought to be an essential feature of Catholicism, namely that the Pope is infallible on spiritual matters, and that he has the supreme authority in the civil affairs of other countries. Right? Those two ideas were thought to be, according to Protestants especially, right, the most dangerous kind of ideas. Like, you don't want people in your country who believe that an external authority has jurisdiction over your nation. Right? Wars are fought over this, right? So according to Protestants, these beliefs made Catholics politically dangerous. But if you remove that idea, if you don't think, right, that the Pope has this kind of power, then you empty the set of reasons why Catholics can't be tolerated politically. So as I argue in my book that Mike mentioned, Our Dear Bought Liberty, Catholics denied this kind of papal authority. They were what I call anti-papalist Catholics. And so by denying this thing, you remove, right, the reason why they had been prohibited from holding public office. Well, there's an even more simple explanation for why there is a no religious test clause, I think, at least in the case for Catholics, which is that there were two Catholics at the Constitutional Convention, right? Daniel Carroll and Thomas Fitzsimmons. So if you wanted to create a clause that continued the long-standing tradition of excluding Catholics from public office, you would have to embarrassingly exclude, right, two people who are already there at the Constitutional Convention. And also a point about federalism that we'll talk about later on, it'd be a performative contradiction because these states had elected these Catholics to a governing body. All these explanations provide, I think, a much richer account of the kind of causal ecosystem of Article 6. So let's now turn to the religion clauses of the First Amendment. Given the sparse generating history of this amendment, it's very difficult to find influences. There's a lot of theories here. Mike introduced a few of them, right? Some people think this is a secular text meant to keep religion out of politics. Others say it was meant to protect religion so that the government wouldn't favor one sect or another. Still others think it's a kind of like peace treaty in which we're just trying to get religions from combating each other and even causing civil strife. Still others think it was a very simple, modest jurisdictional comment about how Congress can't establish a church in the United States and that this free exercise is really just the free exercise to worship in public. So there are lots of theories, all of which I think in kernel have merit to them. But investigating the Catholic context to this, I think, can merit some new insights. The first thing to note here is that there were two Catholics at the creation of the First Amendment, Congressman Daniel Carroll, that I mentioned before, and his second cousin, Senator Charles Carroll of Carrollton, who also signed the Declaration of Independence. They believed generally with Madison this Federalist point, that really the sovereignty of states on the question of religion really rested within the states. And so they didn't think an amendment about religious freedom or establishment and so on was, strictly speaking, necessary at the federal level. But after Madison proposed his amendment, Daniel Carroll was the only congressman in New York, where the first Congress sat, to support the measure explicitly and without further amendment. I think it's worth quoting Daniel Carroll's speech in full here as we receive it from the Congressional Register. As the rights of conscience are in their nature of peculiar delicacy and will bear little the gentlest touch of governmental hand, and as many sects have concurred in opinion that they are not well secured under the present Constitution, he said he was much in favor of adopting the words. He thought it would tend more toward reconciling the minds of people to government than almost any other amendment proposed. He would not contend with gentlemen about the phraseology. His object was to secure the substance in such matter as to satisfy the wishes of the honest part of the community. Note here that Daniel Carroll does not give a uniquely Catholic argument, if there is one, for supporting this amendment. He seems mostly concerned with reconciling anti-federalists to the Constitution. So we might call Daniel Carroll here a kind of godfather to the First Amendment, right? A support, right? A kind of sponsor to it. Not the progenitor, but a sponsor. But I think it's worth looking at just the specific speech here. It was printed, as I mentioned, in the Congressional Register, which later became the quote-unquote official record of the First Federal Congress. But this is not a verbatim script. It is editorialized language by a journalist named Thomas Lloyd. And with Lloyd's pen, Carroll's remarks were longer, much longer than other congressmen, and much more stylized. It has the kind of elevation of oratory to it when you compare it with the other recorded remarks. It turns out that Thomas Lloyd, the creator of this record, was Catholic. He studied at the same Catholic college that Daniel Carroll had attended, that Charles Carroll attended, and that Bishop Carroll had taught at. In fact, he was a student of Carroll. So almost everything we know about congressional debates, if you're an originalist out there, right, comes from a Catholic journalist who very clearly is editorializing the record to favor his fellow Catholic and Federalist. Unfortunately, Lloyd's sparse congressional record does not disclose Congress's underlying reasons for adapting the amendment when it went actually to the committee itself to finalize the language. We do not have a record of it. We do know that Charles Carroll of Carrollton was there in the finalizing committee. And that in itself, I think, is an impressive thought given the long anti-Catholic history. So I've argued that there were Catholic influences in the Constitution relevant to the religion clauses, even if they were modest and often circumstantial. While there are other, doubtless more important influences, Protestantism, natural rights theory, Enlightenment ideas, these interpretations don't fully explain how Catholics were included and helped to shape American founding texts. So while this nuance of influence does not neatly fit into many public debates about the role of religion that it should or shouldn't play in America, it is, I think, the only way we can be truthful about our history and in doing so honor America in its 250th anniversary. Thank you.
In essence, what do we think about the founders having a Judeo-Christian perspective and wanting that for the nation? Yeah, I mean, that's a great question, and it's certainly one that's debated a lot among scholars of the founding and religion. So I think it's indisputable that they were coming from a Judeo-Christian perspective. They were all Protestants of one stripe or another, except for the few Catholics who were as we've heard somewhat excluded. But I do think that they intended religious liberty to apply to everybody and of all religions. And speaking about Dickinson in particular, Quakers believed that all people could be saved if they accepted God's light in their conscience, and this included even people who had not heard of God or Jesus Christ. So Native Americans, for example, they believed anybody, regardless of their knowledge of God, could be saved. So, so that would seem to extend, certainly to people who were Muslims or one of the many Native American faiths. And Dickinson himself had a very sort of ecumenical approach. Throughout his papers, we find quotes that inspired him, from various religious traditions, not just Christianity. And I think his concern was more that a group of sort of zealots might dominate and oppress minority religious groups. Anyway, that's kind of my take on it. Thank
you very much for the question. Another aspect of your question, as I heard it, was what was their views of other religions other than Judaism and Christianity. If you've met one American founder, you've met one American founder. They have lots of different views on many subjects, and there were very few Muslims in early America. The scholarship I've read, I'm not an expert in it, but that they would likely have been more likely to have been enslaved people who are practicing Islam from Africa. I don't have any evidence of Hindus. Certainly a lot of Native American religions the founders would have been exposed to as well. And so a lot of the founders were aware of Islam, Hinduism, Native American religions of various kinds. Mormonism doesn't exist yet. So they're knowledgeable about it, but of course it's refracted through, right, the texts that are available to them. Thomas Jefferson, for instance, has a copy of the Quran. Most founders have some sort of semblance of the 5 pillars of Islam, and so it's very much refracted through a Christian lens, I would say. That complicates the picture, obviously, of the religions. The religions, as it were, are not speaking for themselves for Islam and Hinduism. And they use terms about these religions that people would find derogatory today, right? Native American religions is quite interesting because, of course, there is exchange and strife with regard to Native American religions and Christianity. There's lots of efforts, federal governments finance efforts to what they would call sort of educate Native Americans, but of course it also was, as they put it, a civilizing, and I would also underscore evangelizing effort, because the federal government paid Protestant and Catholic pastors and priests to go to Western territories to preach, frankly, the gospel to Native Americans. So it's a very complicated set of understandings about religion and its interactions.
No.
Okay. So I'll just say quickly, it's a great question because it pushes not only, as my colleagues have said, on historical buttons, but it pushes on conceptual buttons. And that is, what is religion? What do we mean by religion? So there's no sort of the definition doesn't sort of fall from the sky on us. And it's a concept that is going to be conditioned by the circumstances in which a particular society exists and in which it thinks. And I agree with my colleagues here that that society, when the Constitution was ratified, was a Christian society. It was a Christian society in the sense of that Christian concepts formed, Christian outlook formed its general presuppositions about things. It wasn't a Christian society in the sense of an established church, but it did form the sort of cultural background and makeup against which lots of things were thought about. And by the way, I think that continued in the 20th century when we see some of the disestablishment decisions that I talked about post 1947. Those weren't really about, in my view at least, disestablishing religion. They were about disestablishing Christianity as the fundamental set of presuppositions. If you look at the cases, those cases were, generally speaking, against Christian monuments, Christian prayers, cases that presupposed in what they were attacking, a Christian cultural makeup. I think today you're quite right. It's not just Islam or Hinduism. I think the very concept of religion has been sufficiently destabilized that we are at a very different place. We're in a different cultural, sociological place than the founding place was with respect to the kind of conditions about thinking about what religion is, which makes it much, much more difficult to establish anything coherent about the concept. And I think you're seeing some fractures in the law, some problems in the law with respect to the coherence of what religion is, which will only become, in my view, worse in the coming decades.
Thank you for that question. And it was, did the founders and Dickinson see sort of any limits to religions that could be potentially sort of damaging to the public? So I'll begin my answer about Dickinson with Jefferson. Dickinson was a Jeffersonian politically. So Jefferson was really very much sympathetic and a participant with the Unitarians in actively trying to exclude evangelicals from public life, and specifically from the University of Virginia. The Unitarians and Jefferson believed that evangelicalism was deeply threatening to American public life, and sought to eradicate it. They wanted to lay the grains of gunpowder under the evangelical establishment and blow it up. So I think Dickinson shared that sense that evangelicals were dangerous. He said, so thinking about the benefits of Christianity for public life, he said, what must be the effects of the Christian system divested from the creeds of bigots and the reveries of enthusiasts? And he went on to say, reason then would no longer be displaced to make way for faith, nor the testimony of nature be degraded by the evidence of revelation. So I've never seen any indication that Dickinson wanted any kind of laws to exclude any kind of religion. Like Quakers, he believed in really the free exercise and the power of persuasion to convince people to sort of come, not to become Quakers, but to act like Quakers. So what Dickinson believed was that reason and religion were so closely related that's what would make religion useful for public life. So no laws, but persuasion and education to make sure that reason and religion were very closely paired, especially for the education of youth.
On the question of whether Catholics had a conception of any limits to religious liberty, Catholics, especially, I'm channeling here, sort of their leader, Bishop John Carroll, did not think of religious liberty as a license for licentiousness. They did not see it as a way to smuggle in unlawful behavior. And this was especially important to note, given the history of people thinking that Catholics are uncivil and politically dangerous. And to answer the flip side of the question that was implicit, which is what is it for then, right? It's for the search for right religion. There's a teleological argument here that the Catholic Church is the one true church, and everyone needs to finally see that. And so the freedom there is in search of that particular truth, even though Carroll did not believe in established religion as a way to get to that truth. He believed in the reasonability of his religion and therefore the kind of way in which people are using their reason to find the preambles to the faith. So, but yes, I would say that is a kind of general description of sort of thinking about this, that religious liberty is not carte blanche, sort of absolutist.
Mike, your question was about whether the court was responding to the zeitgeist in interpreting the Establishment Clause to be an individual right in the mid-20th century. And I would say, yes, in part. Law, in my experience, responds, but it also leads. And the justices on the court of the mid-20th century were certainly interested in leading. So I wouldn't say that they were responding to the zeitgeist. They were in some ways just as much trying to burn that zeitgeist down. They were trying to change American society. And the one example that I can raise here, the dissenting opinion in Everson, which actually took a more extreme separationist view, was written by Justice Rutledge, Wiley Rutledge, and a friend and colleague that Michael and I both know, Don Drakeman, has shown fairly conclusively that Rutledge got all of his historical information from a historian, a contemporary. Do you remember his name, Michael? Bancroft. And a sort of a elite university historian. All of a sudden foregrounding Thomas Jefferson's Danbury Letter to the Baptists. Jefferson, who had no role at all in the drafting, the composition of the Establishment Clause. So yeah, I think it was, yes, a response in some sense, but a response to certain elite pressures, tendencies, of which the justices were, in which group the justices already found themselves. And the last thing I'll say is, don't sleep on the role of the Free Exercise Clause in shifting the zeitgeist. Sometimes it's thought, it's the Establishment Clause that's the primary driver here in destroying the sort of soft cultural Christianity, and that's true. But in the presentation that I made, I also talked about the movement back from a reading one to a reading two approach to exemption. That was done in connection with a kind of flattening out of what religion was, an application of religion to the weird, to the strange, to the sort of minor phenomena, a reading of what religion was, so that it no longer was about traditional faiths with long histories, but instead about marginal phenomena, which itself had a destabilizing effect on the meaning of religion for both clauses. So this sort of pincer effect of the Establishment Clause as a sledgehammer and the Free Exercise Clause as a sort of flattener was definitely, in my view, in the justice's mind as a way to attack the zeitgeist just as much as to respond to it. I can talk about that case. If I'm sure, as I'm sure you know, that came with a companion case, the McCreary County case. It was two cases involving religious displays, and my memory, at least, is that Van Orden, the critical vote in those two cases was Justice Breyer's vote, because Justice Breyer said in one, the religious display was sort of not objectionable or not objectionable on what he took to be Establishment Clause grounds. But in the other, in Van Orden, in the Ten Commandments case, he did sort of say that, this is as a matter of sort of historical practice and tradition, a display in that context in the exterior grounds rather than in the interior, which was the case in the other companion case, the McCreary case, of the Ten Commandments wouldn't have conveyed a sort of message to a reasonable observer of promotion of religion. Now, I don't agree with either that test or Justice Breyer's view of that test. But I think it's fair to say that the display of religious monuments, and in particular Christian monuments, especially ones that have been around for a long time, that display carries with it many different kinds of meanings. Some of them are overtly religious meanings. Some of them are historical meanings. Some of them are war meanings. Some of them are a kind of mix where it's difficult to disentangle one meaning from another meaning. And so I think, I'll give you another example, the American Legion case, which was about a cross in Maryland that had stood on a public thoroughfare, and a bunch of folks said, you know, I'm irritated by that cross. I don't want to see that cross any longer when I drive down the highway. One solution that had been proposed was just lop off the arms of the cross. That's neutral. Now it'll be neutral, right? We'll just have a big old beam on the highway. I think all of this goes to the problem of neutrality as to religion. And it shows why taking a culturally, contextually rich approach to thinking about what a monument means or what it represents, especially one that has been around for a long time, probably has a certain amount of wisdom in it.
James and Piehler, for giving me a chance to talk about Morris. I know Dennis feels the same way I do. It's such a treat to get to talk about him. Hear me well enough? Is that better?
Yes.
I stand sorry. And also I must say that the Institute concept sounds absolutely terrific. Very impressive. So, but in this time of celebrating the 250th anniversary of the Declaration of Independence, I'd like to think that Morris is perhaps about to find his moment. For the past 200 years, his virtual exclusion from the historical picture and the denigration with which he's been treated continues to flatten our understanding of that period and our enjoyment of that period of American history. And I'd like to think that neglect will end. It should end. Restoring Morris doesn't just complete the record, it enriches it in so many ways, by speeches in the convention and Senate, and by his truly extraordinary diary of the French Revolution, his letters, and also the actual events of his life, which belong to all of us, and I can tell you they're worth studying. His acute observations are made in a modern voice, and his political comments, whether humorous or agonized, are truths expressed with an eloquence that definitely resonates today. So I've been asked to talk a little bit about his life. So here we begin with a wonderful bust of Morris. It was done by a French sculptor Goudon in 1789. And this is really the only truly realistic portrait we have of Morris. Here he is, you know, Hamilton's best friend. That's what Hamilton's wife called him at Hamilton's deathbed. I will have to say that Hamilton was not Morris's best friend, but that's not something we're going to be able to address today. I also wanted to start off with one of many quotations from Morris that have stayed with me over the decades of working on his papers. I had actually a list of them, and I hope they'll strike you because they show that understanding of human nature that influenced his approach to the Constitution and the continuing validity of his insights. Now, do I just hit the green arrow to go forward? Okay. This is it. The true object of a great statesman is to give to any particular nation the kind of laws which is suitable to them and the best constitution which they are capable of. He wrote that during the French Revolution. He was born in 1752 on his ancestral estate of Morrisania in the Bronx. And he was 9 years younger than Jefferson and 20 years younger than Washington. The household was an affluent one. His father was a vice admiralty judge. But Morris was the young son of a second marriage, so he didn't inherit much when his father died. But Morris was very bright, and he entered King's College, which was later Columbia University, when he was only 12. And when he graduated, he served as a law clerk and was admitted to the bar when he was 19. He wrote beautifully. He was known as a great speaker. He could be very funny, and he loved to laugh. And as his diaries show in France, he respected women and he liked them. He often discussed political issues with them. He was tall, good looking, and generally well liked. And he was exceptionally talented in his grasp of finance and economics. Even when he was only 17, he wrote a paper that was published criticizing the New York Assembly for issuing loan certificates, for a plan to do that. When the American Revolution came, Morris, like many, hoped that the colonies would reconcile, but because he was worried that the resistance would disintegrate into mob tyranny, but he was fully committed by 1775. And he was elected to the New York Provincial Congress, and in 1776, he and John Jay wrote the first New York Constitution together. He took positions that were similar to those he would take later at the Constitutional Convention, arguing for a strong executive, something he always believed in, and the provision that would recommend that future assemblies abolish slavery. He was sent to the Continental Congress as a delegate in 1777 and was soon sent to join Washington at Valley Forge to review the Army organization and reorganize its supply system. Morris had heartfelt admiration for Washington, and it's clear that Washington really liked him. He recognized his talents, and he enjoyed his company, because even in the worst of days in that war, Morris was exuberant and irrepressible. In Congress, Morris chaired many of the important committees. He wrote their reports, and when France officially allied with the United States, it was Morris who wrote the instructions to Benjamin Franklin as our first minister. Morris became the contact point for the French in America. He was not reelected in 1779, political infighting stuff, but in any event, in 1780, he had a carriage accident in Philadelphia, and he lost his left leg. This is one of them that's in the New York Historical Society. It was a terrible blow to a man in his prime, but he, particularly I should add, because he inherited the family curse of gout, which if any of you have any personal experience with gout, it's terrible. And he would get it in his right foot so that he was immobilized when he would have an attack. But it never kept him from doing what he wanted to do. He traveled everywhere, up and down the east coast of America, around Europe, around England, and Scotland. And it was actually his second significant injury. He'd been burned badly on his right forearm when he was young, and that had taken him practically a year to recover from. In 1781, he became the assistant to Robert Morris, that's a portly gentleman on the right. And they weren't related, but Robert really thought highly of the governor and relied on him a great deal, as Robert Morris was the superintendent of finance, and Morris, governor, was his assistant. They worked well together. They established a national bank. They helped shore up the nation's very shaky financial situation. And Morris also presented a plan to the Continental Congress for retiring the public debt, but there was too much opposition at that time to that strong a central government. After the war, they went into business together, buying large tracts of land in upstate New York and Pennsylvania. In 1787, Constitutional Convention, looks familiar, Morris had encountered many of the problems with the Articles of Confederation, and he knew that, believed that unless they were solved, the Union would dissolve. So he reluctantly agreed to be a member of the Pennsylvania delegation. And his work at the convention is going to be addressed by Dennis. But it does give me a chance to put up one of the quotes from the convention that always has stuck with me too. This one. The rich will strive to establish their dominion and enslave the rest. They always did, they always will. I fear the influence of the rich. They will have the same effect here as elsewhere if we do not keep them within their proper sphere. We should remember that the people never act from reason alone. The rich will take advantage of their passions and make these the instruments for oppressing them. And this is coming from someone who was called an aristocrat, and he understood the patrician class very well. In late 1788, he left for France on business for Robert, and he began keeping his diaries. This is just a picture of one of the volumes that's in the Library of Congress. And I don't have time to tell you about his experiences there, but it is fascinating. And an important aspect to remember in considering Morris's posterity is that unjustified attacks on him and falsehoods about him made while he was in Europe left a permanent stain on him at that time and even up today. I was speaking to someone today who was telling me things that pained biographers are still saying about Morris. So anyway, what I will refer to here, first let me just show you this. Morris was the only diplomat to remain in Paris after the king fell. This is the attack on the Tuileries in August 1792. Maybe I forgot to mention, he was appointed minister in 1792. And Jefferson had left in 1789, so he replaced him. In any event, it was a really difficult job, thankless, frankly. There were something like 7 different heads of different regimes during the time he was there, and everyone was the mortal enemy of the previous one. So, how do you get along with them? It was really tough. And I think he did an honorable job, but what I'll just refer you to is what Teddy Roosevelt said about this, because he wrote a short biography of Morris, and he said, Morris's service in France stands by itself in diplomatic history. We've never had a foreign minister who deserved more honor than Morris. In his whole attitude toward the French Revolution, Morris represents better than any other man the clear-headed, practical statesman who is genuinely devoted to the cause of constitutional freedom. Morris was replaced by James Monroe in 1794, but he remained in Europe until the end of 1798, partly trying to sell land and also trying to get Lafayette released from an Austrian prison. This is just a little picture of Lafayette with his wife and children and Olmos, which Morris was successful in doing, did not get credit for, but he did it. Back in the United States at the end of 1798, he agreed to serve out a senator's term for New York in 1800. This is just a picture of the Capitol in 1800. And in that position, he saw the changeover of power from the Federalists to the Anti-Federalists, where it stayed until well after his death. He was appalled by the Jefferson and the Jeffersonian Congress repeal of the Judiciary Act, and he considered it a breach of the Constitution, and he considered the Constitution dead after that. The remaining 13 years of his life were spent working to promote settlement in upstate New York, heading the Erie Canal Commission. He headed the Manhattan Street Grid Commission. That's why we have the Manhattan we have today. And he also had periods of illness that were debilitating. One lasted 10 months. He couldn't write in his diary. He was angry and contemptuous about the incompetent diplomacy, what he considered incompetent and zigzagging diplomacy of Jefferson and Madison, and outraged by the damage that it did to the Northeast economy, including New York State, with the sanctions and embargoes and their attempts to play the British and French off against each other, which did no harm to either of those countries. He bitterly opposed the War of 1812, which he considered entirely avoidable, and a thin veneer over a Republican intention to conquer Canada. And in the conviction that the Southern-dominated government had effectively abandoned its obligation to protect the northern states, he advocated secession from the Union. Where that movement might have gone, we don't know because the war ended. But it was a war in which, as Morris pointed out, none of the stated U.S. war aims were achieved. He came close to financial ruin during the war because it paralyzed land sales and also because of the perfidy of a trusted nephew who signed Morris's names to loans and then defaulted. He died in November 1816 at the age of 64. Now, I just wanted to put on a couple more quotes if I have time, because I think they're so great. They have made the common mistake that to enjoy liberty, it is necessary only to destroy authority. All these, to me, reverberate right through the centuries. I already quoted that one about what he felt about religion as a base of morals, and that morals were essential to a free government. Like this one, suspicion, that constant companion of vice and weakness, has loosened every band of social union and blasts every honest hope in the moment of its budding. These are things that he was seeing in France, but they really only bore out what he already knew and which informed his positions at the Constitutional Convention. And yet he expressed them more eloquently, perhaps, afterwards, when he was seeing it in real life, which was what was going on there. This one, virtue once gone, freedom is but a name, for I do not believe it to be among possible contingencies that a corrupted people shall be for one moment free. That was right before the terror. Really like this one. I have lived too long to regard men's expressions, so that all sentences rounded off by fair or foul words such as liberty, patriotism, virtue, treason, aristocracy, crime, are to me the equivalent of blank paper. This one's too long for me to read, but what strikes me about it is it expresses his love for the French but his feeling that they simply could not handle the Constitution they had been given, which had fallen apart. And he ends up by saying, he had hoped that it would extend the blessings of freedom to the many millions of my fellow men who've grown in bondage on the continent of Europe. But I do not greatly indulge the flattering illusions of hope, because I do not perceive that reformation of morals without which liberty is but an empty sound. And that's just about all of it. These are ones that I find very interesting to think about today. He's talking about what does it matter if you have a written constitution? The legislative lion will not be entangled in the meshes of a logical net. They will always make the power that they wish to exercise and then justify it by saying, well, that's what it meant. So that he says that they are avoiding the shame, if not the guilt of perjury when they do that. The idea of binding them by their oaths is puerile. That was very interesting. He wrote that when the War of 1812 was going on. And I thought this one was another one of interest. What can a history of the Constitution avail towards interpreting its provisions? This must be done by comparing the plain import of the words with the general tenor and object of the instrument. And I will close with a wonderful quote from Willard Townsend Adams, who wrote a great biography of Morris. He was a wonderful writer, and he wrote this. The question is, are we capable of cutting through the Jeffersonian fog to see the founding generation in far richer detail, and see federalism as something more serious than a fleeting aberration? The question is whether we are mature enough as a nation to comprehend Morris's greatness. That's it.
Okay, so let me add my thanks to Ryan for the invitation and everybody who helped to make this possible. This is a special treat for me. I actually attended Florida State my freshman year. I'm from Michigan, but I came down here for my freshman year. I thought it would be an adventure, and it was. But I was, an 18-year-old kid. I was a little bit homesick, and I was still dating my high school girlfriend. Looking back, I was just doing college wrong. But anyway, I transferred back to Michigan State after just 1 year. But it was a pleasure. I took a stroll down memory lane, walked around the campus for the first time in 30 years this morning, so that was fun. So very pleased to be here. Thanks to Melanie for giving us a great overview of Morris's life. As you saw, super colorful guy, the peg leg. He's one scholar said recently that he might have been the most colorful individual in all of North America at the time of the founding, and that I think is right. I'll add, Melanie said it, but I'll reiterate. He was super funny. He was without question one of the funniest of the founders. That's not a super high bar. I think Franklin is the only real rival there, but he's very, kind of sardonic sense of humor, very, very funny guy. But I'm going to focus less on his life. I'm going to talk about his role at the Constitutional Convention and in kind of the forming of the Constitution. And there's a lot I can say because he was perhaps, I would argue, the single dominant figure at the Philadelphia Convention that produced the Constitution. You wouldn't know that from reading a lot of books about the Constitution, where James Madison is the father of the Constitution. But Morris spoke more often at the convention than anyone else. He proposed more motions at the convention than anyone else. He had more motions adopted at the convention than anyone else. His speeches, his interventions in the debates are very blunt, very provocative. If any of you have read through Madison's notes, they leap off the page at you, right, as you read through them. He served on a number of the committees that did really the hard work, the important work of forming the Constitution. I think it was only 3 delegates served on more committees than he did. And most importantly of all, I don't want to bury the lead on this, he was the one who wrote the Constitution itself, right? So at the end of the summer, somebody has to write it up. They create what's known as the Committee of Style that writes the Constitution. And it's a 5-person committee, but by all appearances, they just handed the role to him, right? And it's astounding to me how few people know this. Everyone knows. Most American school children can tell you who wrote the Declaration of Independence, right? Very few people know who wrote the Constitution. I bet if you polled PhDs in political science, probably it's a pretty small, I don't know, I've never done a formal poll. It's probably a pretty small fraction that could tell you who wrote the Constitution. I've asked many people this question over the past few years since I started working on Morris. Many people are just flummoxed. They say, oh no, Madison must have written it, or maybe it was just a group effort. And then I guess that's fair. In some sense, of course, it is a group effort, right? The delegates had spent, the whole summer laboriously voting and debating all the provisions. So it's not like Morris could just, pick the form and structure of the government out of his hat. But I do still think it's fair to say that he wrote the Constitution every bit as much as Jefferson wrote the Declaration of Independence. He single-handedly, rather radically reorganized so there was a draft constitution midway through the summer by what was known as the Committee of Detail. There's 23 pretty sprawling articles. He consolidated it down to a neat 7. He changed or chose a great deal of the wording on his own initiative, oftentimes in consequential ways. And so when we, when constitutional lawyers and historians, scholars pore over the fine details of the document, right? Why this word rather than that word? Why this semicolon? Whatever. Most of that's Morris's doing. And he wrote the famous preamble, basically from scratch, the ringing statement of purpose, all the stuff about forming a more perfect union, securing the blessings of liberty, that's all Morris. So anyway, the point is, Morris is definitely more than anyone else the author of the Constitution, one of the most important texts in world history. Now, my most recent book is on Morris's constitutional vision. In the book, I go through his views, his impact on each of the branches and slavery and so on. I'm gonna, since we're trying to keep ourselves to 10 or 15 minutes here, I'm gonna go reasonably rapid fire. But let me say a couple words about a number of the big topics. I'll start with federalism, the role of the states vis-a-vis the national government. Here his views are pretty much straightforward. He wanted the national government to be as powerful as he could get and to minimize the power of the states as much as he could get. He's really one of the leaders of the nationalist camp at the convention, along with Madison and James Wilson. Nationalists, of course, meaning not America first in the international realm, but augmenting the power of the national government at the expense of the states. He wasn't the most uncompromising nationalist. I think that probably goes to Hamilton, who would have basically wiped the states off the map if he could have, and I don't think Morris would have gone that far. But what I suggest in the book is he's maybe the most passionate nationalist at the convention. So this is a time, remember, right, in the writing of the Constitution, the states are still the sovereign powers in America under the Articles of Confederation. And this is something Morris definitely thinks needs to be changed. He thinks, like Madison, Wilson, and others, he thinks the state governments are deeply problematic, partially because of their own internal problems, no real protections for minority rights against majority tyranny, but also just that they so frequently stood in the way of the national interest. So at one point in the convention, he stood up and asked, quote, "If all the charters and constitutions of the states were thrown into the fire and all their demagogues into the ocean, what would it be to the happiness of America?" Which I think would have raised a lot of eyebrows during the convention. But he's constantly saying, we need to not think of ourselves, most of the delegates think, I'm here to represent Delaware or Georgia or Massachusetts or whatever it is. He says, we're not here to truck and barter for our particular states. We should think of ourselves as representatives of America. That's what he called himself. So he has this strong nationalist vision. All right, so the three branches. I'll start with Congress. So of course the biggest debate at the convention over Congress is the basis of representation. So is in the House or the Senate, is it going to be based on, representation going to be based on population or equal votes for each state or whatever? Morris was firmly in the typical large state camp, which is to say he wanted proportional representation in both houses of Congress. That he thought it was just patently unjust to grant some citizens more effective political power just because they happen to hail from a smaller state, right? And this is what equal representation would do and does do, right? And so this is one, we tend to think of the so-called Connecticut Compromise, right? We get proportional representation in the House, equal representation in the Senate. This is a nice, happy, even Steven compromise, right? Both sides win something, both sides lose something. Most of the big names among the founders, and here Morris, but Washington, Hamilton, Madison, James Wilson, took this as a devastating defeat. Most of them thought about walking out. They thought, is it even worth adopting a constitution where we have equal representation in one of the branches? They thought it was patently unjust. We're totally disgusted by it. Let me just say a couple words about his vision for the Senate. So I'll skip the House and say about his vision of the Senate, because he has a very counterintuitive view of the Senate. He gives a long, audacious speech on July 2nd at the convention, where he argues that the Senate should be made up exclusively of wealthy individuals who are chosen by the president to serve for life without pay. And strangely, he thinks this is going to serve to check the political power of the rich, right? So one of the first quotes that Melanie gives us about the corruption of the rich, whatever, that's from this speech, right? So this is, how do you explain this? How would that be? So he says, well, okay, why do we have a Senate at all, right? Why do we need a second branch in the legislature at all? And he says the purpose of the Senate is to check what he calls the precipitation, changeableness, and excesses that he assumes will characterize the House of Representatives. So the House, he thinks, is going to be this kind of turbulent populism. And he thinks, okay, well, this kind of Senate that he's envisioned is going to be in a good position to do this. If the senators are all rich, then they have an incentive to protect private property against sort of populist inroads against it. If they have lifetime appointments, they don't have to worry about re-election. They have the kind of independence to do this. And this is something I should say, the idea of having the Senate be a quasi-aristocratic body with lifetime appointments, a number of other delegates wanted the same thing. A surprising number wanted the same thing. But Morris's reasoning is unique. Most of the others wanted it because they trusted wealthy elites more than the common people. They thought, rich people are smarter, they're going to make wiser decisions. Morris advocates this precisely because he doesn't trust them. So again, as Melanie's quote showed us, he thinks they're corrupt, they're power hungry, they're out to oppress the poor. And so the obvious question is, well, then why are you going to hand the Senate to these, corrupt people? And his argument, I don't think it's persuasive, but it's interesting. His argument is, he says, actually, they're going to be easier to restrain if we confine them to the Senate, right? Like, put them in this one body. We can watch them. We can watch them like a hawk. The people and the people's representatives in the House can, be at the ready to resist any oppressive measures that they try to pass. So he's trying to pit ambition against ambition, right? To use Madison's dictum from Federalist 51. Again, I wouldn't be in favor of this. I think that this has its problems. I wouldn't even go through the problems. I'll just say, somewhat in his defense, he's grasping for some solution, some way to limit the inordinate influence of the rich on the political process, which I'd argue is a problem we still haven't solved adequately in the United States. So, he sees this as a problem. He's more than maybe any other delegate. He's trying to come up with a remedy for it. But anyway, he doesn't get his way, frankly, on very much when it comes to Congress. His vision of Congress is very different than what we ended up having. With the presidency, he's much more successful. So he was, along with James Wilson, one of the two chief architects of the presidency as we know it. I'll start with presidential selection. So how the president is chosen. This is, I think, the second biggest bone of contention at the convention, after the basis of representation in the Senate. They spend more time wrangling over presidential selection than any other issue. And I don't think many people today realize just how close the convention came to having Congress choose the president, which, of course, would have gone a long way toward making the American system a parliamentary system rather than a presidential one, right, to use today's terms. And this is, for almost the entire summer, all but really a couple weeks, almost the entire summer, the plan on the table included congressional selection of the president. And this, I think it's fair to say, would have absolutely passed were it not for Morris and Wilson both opposing it so strongly. Morris had two main reasons for opposing congressional selection. Namely, he said that the choice would just be the result of kind of partisan infighting, factional infighting. He said it would be like the election of a pope by a conclave of cardinals. And then also just that it would render the president subservient to Congress, right? It would undermine the separation of powers. And so what he advocated instead, like Wilson, what he advocated instead was a popular election of the president, let the people choose. This had no chance of passing. Almost all the delegates besides Morris and Wilson found this utterly preposterous, that the people could be trusted to choose the president. And so as an alternative, the two of them, again, Morris and Wilson, devised the Electoral College as the closest thing they can get, basically, to the popular election. And I won't go into, the Electoral College solved problems with regard to the small states, and especially the slave states that would take me a long time to get into. But I'll just reiterate, Morris himself, despite being one of the architects of the Electoral College, he saw that as a second best. He would have preferred direct popular election. Morris also wanted to do almost everything he could to empower the presidency. He advocated that the president have a veto that could not be overridden by Congress, a role in setting the legislative agenda, almost unbelievably expansive appointment powers. So he thought that the president should be able to appoint cabinet officers, federal judges and justices, and remember also senators without congressional approval. So basically the president appoints the entire government other than the House of Representatives without congressional approval. I'm not going to go through his argument, it'd take me too long to say why his thoughts on all these issues. He had two general reasons for wanting the presidency to be this powerful, almost as powerful as he could get. One is that he thought they needed to enhance the president's powers to stand up to Congress. He thought Congress was going to be the most powerful branch, the most dangerous branch, and again, didn't think it was structured the right way. The way they were doing it was going to be dominated by the rich and so forth. He also, the other reason, and I think, frankly, one of the biggest reasons he wanted to make the presidency so powerful is that he knew, as everyone did, it was a foregone conclusion that his friend, and I don't think it's too strong to say his hero, George Washington, was going to be the first president, no matter what selection method they chose. And so, his trust for Washington may have blinded him to certain things. I won't go too far on that. Anyway, so on the presidency, I think he deserved, James Wilson is often called the father of the American presidency. I think Morris should share in that title. In the interest of time, I'm just going to skip the judiciary. They spent so little time talking about the judiciary anyway. It was like kind of, one scholar called it the taken for granted stepchild of 1787. They spent so long wrangling over Congress and the presidency that sometimes you're almost pulling at hairs trying to find his vision in the judiciary. But I'll reserve the rest of my time. I want to talk about slavery because this was really his finest hour, I think, at the convention from today's perspective. No one spoke more passionately or more eloquently or at greater length about slavery than he did. He called slavery a nefarious institution and the curse of heaven on the states where it prevailed. So he gives a long speech on August 8th. I'm going to read a passage from it in a minute. This has been called the first abolitionist speech in American public life, which I don't think is quite right, but has at least a grain of truth to it. It's all the more remarkable when you consider the audience, right? Probably a couple dozen people in the room that he's sitting there talking to are themselves slaveholders. So just to set the scene, so he's giving this argument in opposition to the 3/5 clause, right? To counting 3/5 of the enslaved population toward representation in the House, and then thus also eventually the Electoral College. And his basic argument is there's no reason why enslaved people should count according to any ratio, right? So we have two choices, he says. If enslaved people are human beings, as he believed, then make them citizens, let them vote, right? Then they count. But if they're mere property, as the Southern delegates were arguing, well, they shouldn't have been included at all, right? Other property wasn't included, land, horses, cattle, right? No other property wasn't included at all. So the way he saw it was the 3/5 clause was just a way of augmenting the power of the slaveholding South, done in such a way that it gave them an incentive to import still more enslaved people, right? So their political clout is still further increased. So let me read the climax of his speech in opposition to this clause. Morris says, quote, "The admission of slaves into the representation, when fairly explained, comes to this, that the inhabitant of Georgia or South Carolina who goes to the coast of Africa and in defiance of the most sacred laws of humanity tears away his fellow creatures from their dearest connections and damns them to the most cruel bondage, shall have more votes in a government instituted for the protection of the rights of mankind than the citizen of Pennsylvania or New Jersey who views with laudable horror so nefarious a practice." And I won't keep reading, but he goes on to say that giving the South extra representation on behalf of those whom they enslaved would require, quote, "a sacrifice of every principle of right, of every impulse of humanity," right? So talk about being on the right side of history. This is, I guess I should say, for all of his moral clarity and passion and eloquence, he doesn't make much headway, right? The 3/5 clause is included, the slave trade clause is included, the fugitive slave clause is included over his fierce objections. So what I say in the book is he's in some ways the founder's conscience on this issue, but as too often happens, that conscience was too often ignored. I'll say another word about this. Of course, Morris' speech here makes him look pretty good. I also think, frankly, it makes the other founders look worse by comparison, in the sense that historians are always telling us, well, we shouldn't judge figures of the past on the basis of today's values, right? Which I guess is true to a certain extent. But this speech of Morris's makes it harder for me to accept the idea that, oh, the poor founders, as mere creatures of their times, they just didn't know, they couldn't possibly have known any better with regard to slavery. Morris was one of them, and he knew better, and he told them so, right? It's true that he's a Northerner, but he comes from a slaveholding family. His father had enslaved several dozen people when he was a kid. His mother still held 3 people in bondage the year before, when she died the year before the convention. But Morris, for whatever reason, and maybe Melanie knows better, but he's just clear-sighted about this from a very early age. As she mentioned, in the New York State Constitutional Convention, he's only 25 years old. At this time, slavery is legal in practice in all 13 states, and he tries to put in a provision in the New York State Constitution abolishing slavery. He fails there too, just as he would in Philadelphia. But I do think, he was really at his courageous, his far-sighted best when it came to slavery. I'll stop there.
Good afternoon, everyone. Thank you for having me here. Thank you to Ryan, Leela, to the Institute for Governance and Civics for inviting me to be a part of this panel. It's a great honor to be here with you and have a chance to talk about the founding, the Constitution, and in particular the Marshall Court and its role in putting the Constitution into action. And since Dennis skipped over the judiciary, that's nice that me and that Brigid can fill in the gap here. I will say making the transition from Gouverneur Morris to the Marshall Court, it is a bit of a jump. Right now, Melanie did a great job walking us through Morris's life, which goes through the 1790s. But in terms of the constitutional debates, we do kind of skip over a little bit of that. But it does make a certain amount of sense, I think, because there are a lot of similarities between Gouverneur Morris and John Marshall and their constitutional projects. Like Morris, Marshall was a nationalist. He was a federalist. He spoke in the Virginia Ratification Convention in favor of the Constitution. And like Marshall, Morris himself was a proponent and a defender of a robust, independent judiciary. So like Melanie mentioned earlier, Morris is in the Senate, and he's argued against the Judiciary Act of 1802, which was part of one of the Jefferson administration's major attacks on the judiciary. And so Morris is opposing the Jeffersonian attempts to bring the Marshall Court to heel. But even beyond these similarities or contributions to American constitutionalism, I would argue are also complementary. So as has been discussed, Morris is one of the major, not maybe just one of the major drafters of the Constitution. But as Marshall reminds us in the case of McCulloch versus Maryland, it is a Constitution we are expounding. We can't just go with only the text, but there's certain things in the Constitution that have to be articulated. The Constitution leaves many issues ambiguous or open to political contestation. So James Madison argues in Federalist 37, and as Alexander Hamilton argues in Federalist 82, they both argue that certain aspects of the Constitution could only be understood, or in their words, liquidated, through political practice. And I think the great contribution of John Marshall and of the Marshall Court more generally is that they fill in some of these ambiguities left by the Constitution. But what is arguably even more extraordinary than simply the regular task of, judges are going to adjudicate conflicts, they're going to interpret the Constitution. What's so revolutionary about that? Well, on its face, you could say they're just doing their job. But I think what makes the Marshall Court and Marshall himself particularly important and extraordinary is that Marshall performs this task while being intensely opposed by large majorities in Congress and the Jefferson, Madison, Monroe, and Jackson administrations. Right? So the whole view of how we should understand the Constitution, the political branches to a large degree disagree with how it should be done. Yet despite this intense opposition, despite this institutional isolation, you might say, the Marshall Court becomes the most influential court in American history, laying down foundational opinions in constitutional law and doing so often in a way that I think clearly demonstrates the underlying constitutional logic of the judiciary and the essential functions of the judiciary is meant to perform in our constitutional system. So what do I mean by that? Well, step back for a second. I would argue that at its core, the judiciary's primary function is, of course, to interpret and apply the law, including that fundamental law that is the Constitution. Now, while this is an essential role in and of itself, I think there are also 3 secondary roles that the court also serves as part of this core interpretive responsibility. The first one, mediating disputes, or separation of powers disputes between the other branches. 2, mediating federalism conflicts between the states and the national government, but also among the states themselves and the states' relations with other sovereign entities. We can think of Native American tribes here. And finally, 3, protecting individual and minority rights. You think about the 3 branches of the Constitution. The president, of course, is elected by a national majority mediated through the Electoral College. Members of the House, members of the Senate also represent certain kinds of popular majorities. It's only the court, insulated from politics, that is oriented to actually be able to address individual and minority rights. It's in the judiciary where even the individual who's opposed by a popular law can have their day in court, can make their arguments in defense of their rights. Okay. So with the Marshall Court, we see all these functions being exhibited to a high degree despite intense political resistance, and in a way which aligns with the core functions of upholding the Constitution as supreme. So to that first primary function of interpreting and applying the law, of course, that gets to what we always think of the Marshall Court for, that they exercise judicial review, most famously in the 1803 case of Marbury versus Madison. Now, I don't often have a public forum to say this, so I'm going to say it now because it's something that I have to really ingrain in my students, and I'm grading their exams right now, and they still didn't quite get it, so I'm going to say it again. John Marshall does not invent judicial review. If you take nothing from this talk, John Marshall, Marbury versus Madison, does not invent judicial review. Judicial review emerges out of the nature of the judiciary. It is the judiciary's role to interpret the law, to adjudicate conflicts. We might even say they review the law and review it in interpreting and resolving these conflicts. Judicial review itself had been practiced at the state level before the Constitution was even written. It's mentioned throughout the Constitutional Convention. Many of the delegates of the convention, including Morris, assume judicial review exists when they're talking about the judiciary. So please, for me, don't say Marshall invents judicial review. It makes, this is a very academic thing that's gonna be my pet peeve that I really emphasize, but it bothers me. And of course it's exercised by the Supreme Court several times in the 1790s before we get to Marbury. Because you have to remember, judicial review is not simply that they actually declare the law unconstitutional, it's reviewing the law at all and its constitutionality. It happens in the 1790s. What's significant about Marbury is that this is the first time that the Supreme Court actually overturns a law passed by Congress and declares it unconstitutional. That's a significance, because it's in doing that that Marshall does have to articulate why they can do that. Right? Now, Alexander Hamilton in Federalist 78 basically already did, but Marshall gives it a little bit more force, grounds it into the text, and makes it a precedent then that later courts can take on and argue for. Oh, I should mention too. In Federalist 80, Hamilton calls judicial review a constitutional method of giving efficacy to constitutional provisions. So, again, it's a known thing. But again, I think what's significant about Marbury is not simply that Marshall declares a law passed by Congress as unconstitutional. It's that Marshall is able to do so at a time when the judiciary is under attack. Now, the Jefferson administration, when it comes in, so we have to remember the political context. John Adams loses the election of 1800. You have a lame duck president, a lame duck Senate full of Federalists, and they do something that is very political. They essentially pack the courts. They pass the Judiciary Act of 1801, create a bunch of new lower federal courts, put a bunch of Federalists in there, because what are the Jeffersonians going to do when they get in? They all have, these new federal judges have lifetime terms. So it's a way to, it's something that scholars often call partisan entrenchment, right? You entrench your partisans into the least responsive part of the government so they can sustain your program even after you've been elected or kicked out of office. So Jefferson comes in and he and his party, the Democratic Republicans, undertake what I think is probably the most sustained attack on judicial independence in American history. So they refused to deliver judicial commissions. That's the issue at the heart of Marbury. They repealed the Judiciary Act of 1801. They dissolved courts and delayed the Supreme Court's next session in the Judiciary Act of 1802, the very act that Morris said made the Constitution dead. And ultimately, they do impeach some federal judges. They actually remove a lower federal judge, John Pickering. Now that one's not quite fair to say it's political because he was legitimately insane and a drunk. So, pick your battles with that one, I guess. But they did impeach Supreme Court Justice Samuel Chase. He's eventually acquitted. But again, this is a very sustained attack on judicial independence. But in spite of this, Marshall is able to articulate and exercise judicial review in a way that avoids direct political confrontation while simultaneously ingraining it in precedent, which can then be utilized and enforced by later courts. In short, I think this is part of Marshall's genius as Chief Justice, is that he recognizes the structural and political limitations placed on the judiciary, but he's able to leverage the court's capacity for giving opinions in cases to set precedents that would redound to the strength of the court over the long term. It's something that I think is a particular strength of the court, that because they have these lifetime terms, they can think over the long term. Right? They have capacity for this longer term thinking that is present in other offices, but not to the same degree. Now, beyond judicial review, we also see Marshall laying out how the judiciary can perform the other three functions I mentioned. So with regard to separation of powers disputes, we see this in Marbury as well. Marbury is fundamentally a question of separation of powers. Can the executive branch, represented by Secretary of State James Madison, refuse to deliver a commission to a judicial officer? In this case, we have Marbury, who had been appointed Justice of the Peace by John Adams, confirmed by the Federalist Senate. So Marshall, in looking at this case, has to consider the nature of the executive branch, of executive power, and delineate the differences between ministerial and discretionary duties. And ultimately, he finds that Madison does have an institutional responsibility to deliver the commission. Yet, because the remedy requested by Marbury, remember Marbury wants the court to issue a writ of mandamus to Madison, tell Madison he has to deliver the commission. That involves a congressional statute, specifically the Judiciary Act of 1789. So it involves the extent of legislative power, with, in this case, the court finding that Congress could not add powers to its own authority under original jurisdiction. So in exercising judicial review, Marshall shows how the court must often consider not only its own constitutional functions and constitutional responsibilities, it also has to think through the constitutional structure, responsibilities, and functions of the other branches. And then in this case, he performs the ingenious maneuver of denying the court a minor power over writs of mandamus, while simultaneously demonstrating the far more potent power of judicial review. And again, all doing so while avoiding a direct confrontation with the Jefferson administration and the Jeffersonian Congress. Again, it's genius. It's completely genius that he's able to pull this off politically and still grounding it in the law, in the Constitution itself. When it comes to questions of federalism, as I mentioned before, Marshall is a nationalist. This is evident throughout his jurisprudence. In the case McCulloch versus Maryland that I mentioned earlier, Marshall not only gives a Hamiltonian reading of the necessary and proper clause to uphold the constitutionality of the national bank, but he also gives a full account of the national government's supremacy over the states. And then he solidifies this in the series of cases that follow. So Cohen versus Virginia, Osborne versus Bank of the United States. And his interpretation of several other clauses also contributes to ingraining national power into constitutional law. So Gibbons versus Ogden from 1824, Marshall gives a broad interpretation to the Commerce Clause, helping to demonstrate the constitutional protection for a broad national market economy. Similarly, Marshall uses the Contracts Clause as a major tool for enforcing limits on state power, creating a legal environment that could then facilitate the young nation's further economic development. Moreover, it's in the context of restraining state power in the 1830s that Marshall defined and upheld the sovereignty of Native American tribes in the case of Cherokee Nation versus Georgia and Worcester versus Georgia. But this nationalism, I think, has its limits. So in one of his last cases, Barron versus Baltimore, Marshall determined that the protections of the Bill of Rights only applied to the national government and not to the states. And so it's only in the 20th century that you see the court reversing that decision on the basis of the 14th Amendment's Due Process Clause, or its 14th Amendment is from 1868, so long after Marshall. But between Barron and the 14th Amendment, the Bill of Rights is only applied to Congress and not to the states. As to the final function of defending individual rights and minority rights, we can see that function in operation throughout these cases, that the Marshall Court is consistently defending individual and minority rights against the majoritarian impulses of the Jeffersonian and later the Jacksonian revolutions. So as the Constitution operates on individual citizens, the court is positioned to protect those citizens whose rights have been violated by the other branches and the states in a variety of contexts. And so many of Marshall's cases, including those having to do with broad questions of judicial review, national power, federalism, illustrate how the court is structured to be concerned about individual and minority rights, even when those individuals or minorities are out of political favor. So the Cherokee Nation cases, I think, are the clearest example of this tendency, but they're not the only ones. Finally, while my colleague, Professor Brigid Staab, will talk about Justice Joseph Story and his distinctive jurisprudence, and I know she disagrees with me about some of the things I just said, so that'll be fun. I think it is significant to highlight that the justices appointed by Marshall's presidential adversaries, Jefferson, Madison in particular, they vote with him far more often than not, even on major nationalist cases. In fact, there's one of Jefferson's appointees is Justice William Johnson. He's Jefferson's first appointee to the Supreme Court. And later on, Jefferson writes a letter to Johnson, and he basically says, "Why aren't you dissenting more? You're letting Marshall write all these opinions, and I don't like it. Why are you not writing opinions?" And Johnson basically writes back saying, "Well, when you're right on some things, I guess." Johnson does end up writing a few more dissents, but it's indicative, I think, of the fact that justices have agency. Federal judges and Supreme Court justices have agency. They're not simply just doing what the president who appointed them would want them to do. And the court's judicial independence can have a real effect on a justice's behavior. In this case, you would expect, if we're just going to take a political reading of the court, you would expect Marshall to have been marginalized within about 10 years of becoming Chief Justice, because you get all the Jeffersonian and Madisonian appointees. But he's not. He's the leader, he's the foundational figure, the central figure of the Marshall Court, of the federal judiciary, all the way until he dies in the 1830s. Really, if it's just a political thing, that shouldn't happen. But the justices come to agree with it, which also points to him consistently making compelling and constitutionally grounded arguments that even Jeffersonian jurists could agree on. So it's easy in our polarized environment to simply see Marshall like Jefferson did, a Federalist partisan making political rulings from the bench. But if we examine his opinions, we can see the strong constitutional baseline of authority available to the judiciary and the court's central role in resolving ambiguities left in the constitutional system. And as to his leadership of the court, Marshall's ability to make these landmark rulings while maintaining cohesion on the court with these diverse judges, steering it through perilous political waters, speaks not only to his immense talent as a jurist, but his capacity to act, as I think we might describe, a judicial statesman, meriting his epithet, the Great Chief Justice. Thank you.
Thank you to my fellow panelists and to the Institute for Governance and Civics for inviting me to participate in this conversation. Professor Cash offered a great starting point for my comments today, especially in identifying those three secondary roles entrusted to the court to fulfill its constitutional function. I also think that these roles point to some overlap between Gouverneur Morris and Marshall, so there's reason to combine these two figures, because they both saw the court as the primary national body that should determine whether state laws violated the new constitutional arrangement. So if I'm remembering the Constitutional Convention correctly, and the experts on Morris can correct me if I'm wrong, Morris, despite being a strong nationalist, turns to the judiciary instead of supporting Madison's legislative negative on state laws. So he actually sees the judiciary as the route to reviewing state constitutional issues. So I think it's fitting that we also turn to the judiciary to finish our conversation. I'd like to focus my comments today on the court's duty to mediate federalism disputes so that secondary feature of the court, this becomes an essential and extremely difficult task towards the end of Marshall's tenure on the court. While it's certainly true that Marshall had an ability to convince even his Jeffersonian colleagues to join the majority, he is very political in that way, I think that we can actually see many more simmering tensions on the Marshall court that explode once Marshall dies. And it's really in this area of federalism where we see these issues. And when I talk about federalism, usually we think about just the relationship between the state and the national government, or the state governments and the national governments. In the cases that I point out today, I want to suggest to you that federalism is a bit more wide-reaching than just that relationship between the national government and state governments. But actually there's kind of layers of federalism that Marshall is wading into as he hears these different disputes. Generally, there are two common conceptions of the Supreme Court in the early Republic through the 1830s, so really that period of the Marshall Court. First, it's this conception or this view that the court was united, especially when establishing the strength of the national government. This is something Professor Cash got into. McCulloch v. Maryland and Gibbons v. Ogden are great examples of the court's unity here. Marshall weighs state authority in regulating internal matters against the federal authority granted to Congress. He identifies the national purpose of these laws and backs them up with the established aims of the Constitution. And in doing so, he re-articulates the supremacy of the national laws passed in pursuit of constitutional aims, and most of his colleagues agree, right? On a constitutional analysis, they recognize the logic of Marshall's argument and they go along with him. Second, we often think that the state sovereignty question was answered during this period, although not fully solved, by centralizing jurisdiction in the constitutional arrangement. So with the Constitution defining federal jurisdiction and Congress and state jurisdiction and concurrent jurisdiction on subject matter, we find a solution to the clash between competing sovereignties that we saw as a problem in the Articles of Confederation. And by competing sovereignties, I mean as supreme authorities. And those ideas come back up in the states' rights-oriented arguments we see in the 1830s and then later in the 1850s. In responding to this problem and in elevating jurisdiction, the constitutional framers carved out the authority of each level of government by distinguishing what aims and powers the people of the several states entrust to the national government and what they entrusted to their state governments. And so this ensured that state powers wouldn't be overstepped by the national government and vice versa. So that's another big common view we have of the founding, especially in its relation to federalism. I think in general that these conceptions work when we look at federalism vertically. That is, when we look at it solely as the relationship between the federal government and state governments, that kind of view that federalism is solely about national powers and state powers and the conflict between the two. There are still issues that break through, but the Marshall Court can quickly remedy them and often does so in favor of the national government. And this is what Marshall is remembered for, right? The best example of this might be not McCulloch, I think, but Gibbons, actually, where Marshall is faced with New York's argument that asserts a concurrent power to regulate commerce. But Marshall proves that this concurrent power in this situation just doesn't make any sense because it would allow a state to exercise an exclusive power given to the national government, given to Congress. And so Marshall's colleagues agree. But both of these conceptions are challenged when we consider horizontal claims of federalism. So when we step away from just the national government and state governments, and we consider the federal arrangement and the division of authority between governmental levels, but not necessarily dealing directly with conflicts between the national government and state governments. The best example of these kinds of federal disputes are disputes between two states, or between a state and an indigenous tribe or a nation. They're still federal disputes because their mediation is entrusted to the federal judiciary and they affect the constitutional arrangement, but they don't always get our attention because they're not the hot topics of national power and state power. But these are the cases where we see the martial court really divided. And it's where we start to see these tensions emerge. And they're tensions that Marshall tries to hide sometimes, but they really blow up once Marshall is no longer on the court to keep it steady. In these cases, we see that the jurisdiction solution doesn't work. Instead, the court has to wade into the waters of the rights of sovereign states, and majority splinters. Marshall's still able to hold on to a majority, but it's not the unanimous majority that Marshall's used to, and oftentimes his opinions are kind of covering over some serious disagreements among his colleagues. I want to point out two examples that show this. The 1830s Cherokee Nation cases and a boundary dispute between two bordering states. So we have one example of a conflict between a state and an indigenous tribe, the Cherokee Nation, and then a boundary dispute between Rhode Island and Massachusetts that I think really highlights these problems. First, I'd like to briefly discuss the Marshall Court's rulings in those two Cherokee Nation cases, Cherokee Nation v. Georgia and Worcester v. Georgia, and I'll perhaps push against Professor Cash's reading of the cases a little bit in the way that I do that. And then I'll turn to that boundary dispute. I think that the rulings in Cherokee Nation and in Worcester are much more in tension than we usually think. While we get a strong Marshall defense in Worcester, where he defends the sovereignty of the Cherokee Nation, it takes a lot of background encouragement to write his view of the Cherokee Nation before he can issue that ruling. So I want to dive into this tension a little bit in these two cases. They're decided back to back. So one's decided in 1832, that's Cherokee Nation v. Georgia. The next is decided in 1833, that's Worcester v. Georgia. We usually see these two cases as working together. And because of this, they're often celebrated as an early recognition of indigenous sovereignty, right? Marshall is usually viewed as the jurist who gets it right when it comes to the rights of Native nations and tribes. But I think this is forgetting the losses of Cherokee Nation for the gains of Worcester v. Georgia. In Cherokee Nation, while the court says that the sovereignty of the Cherokee Nation has long been acknowledged, Marshall actually offers a new description to the Cherokee people as a, quote, domestic dependent nation. And so in this case, their sovereignty is actually quite limited, and they're not recognized as a nation that can sue in federal courts. This new description seems to undercut his initial statement in significant ways. It seems to say that their sovereignty has not been long acknowledged, because they do not have the right to sue in court. Moreover, Marshall's majority opinion focuses on a jurisdictional question in this case, and it actually makes his opinion different from the arguments we see in a concurrence and the dissent in this case. So Justice Baldwin, a Jeffersonian, I think Jefferson appointee, or if not Jefferson, Madison, he's a Jeffersonian in his view, and Justice Thompson's dissent, which is joined by Justice Story, they both focus on the sovereignty issue. So the question of whether or not the Cherokee Nation should be understood as sovereign. In this case, then, jurisdiction is not able to resolve the sovereignty question, but actually obscures the real divide on the court. The dissenters rally against Marshall's turn here, and they seek to articulate Cherokee sovereignty on political rather than territorial grounds. They attempt to provide a new understanding of what sovereignty might look like in this American federal context of political sovereignty. A year later, Marshall takes on the language and argument of the dissent in Cherokee Nation and now defends Cherokee sovereignty. So in the year before, he calls them a domestic dependent nation, rejects their claim. A year later, he defends Cherokee sovereignty and takes on Thompson and Story's arguments in order to do that. All right, why does this matter for our understanding of federalism? The divisions between the justices in Cherokee Nation point to the uneasy constitutional solution that elevates jurisdiction over sovereignty questions. While this solution seems to manage conflicts between state powers and national powers, like Gibbons, it does not easily resolve conflicts that exist within the horizontal plane of federalism. And state sovereignty arguments really rear their ugly heads in this plane, with some states even arguing that the judiciary has no authority to rule in these matters. So they reject the judiciary as the final judge, right? They're quoting that 1798 argument articulated by Jefferson himself. So the court, and Marshall especially in Cherokee Nation v. Georgia, does not always maintain the nationalist line that we might think. Cherokee Nation is not a nationalist view at all. Soon after Marshall's death, we see this tension in federalism emerge again in an 1838 dispute between Rhode Island and Massachusetts. This case attempts to answer a centuries-long dispute about the boundary between the two states. Apparently, for the existence of their charters, they never resolved the question of where the boundary line should actually be drawn. And they go to court over 5 times to try to figure out this issue. Congress can't help them. It's a mess. Justice Baldwin, who concurs in Cherokee Nation but dissents in Worcester, writes the majority opinion in this case, and Marshall's nationalist stalwart, Joseph Story, doesn't participate. So there seems to be no nationalist voice present in this case. While Baldwin rejects Massachusetts' jurisdictional argument that the Supreme Court doesn't have the authority to hear the case, he goes to significant lengths to suggest the sovereign status of the states as the foundation for the constitutional arrangement. And that seems to be a position that Marshall rejects throughout his tenure on the Supreme Court, right? Marshall always tells us that the people of the United States made the Constitution, not the states. And now, 3 years after Marshall's death, we have Baldwin saying the states created the Constitution, even as he's rejecting this jurisdictional argument. So we once again see that sovereignty really is the main argument. It's not jurisdiction. So what do these cases teach us? They're kind of obscure. They're not the ones you'd really get in your intro to common law class, maybe Cherokee Nation and Worcester v. Georgia. While it's certainly true that Marshall's political maneuvering and constitutional mind allowed the court to develop a nationalist jurisprudence that withstood Jeffersonian assaults, it also came at the expense of the unity we usually attribute to the Marshall Court. So we actually see him prioritizing nationalism over the unity that we usually associate with his court. Marshall was able to build a strong conception of national power in relation to state power, but that doesn't seem to tell the whole story of American federalism. The constitutional arrangement instead suggests layers of federalism, layers of delegated power, and Marshall acknowledges those layers that involve more relationships than just the binary relationship between the national government and the state governments. The challenges that emerge later on in the antebellum period start to make that really clear, and the fractures are all over these issues: federalism, of sovereignty, the rights of the states. Marshall and his colleagues seem to make great advancements in strengthening the vertical conception of federalism, but that's only one half of the federalism story, and later political figures begin to chip away even at that half as we go towards the 1860s. I'm happy to turn things over for a discussion now, but thank you very much.